be seated. Well, we have two cases set for this morning's docket. The first one is Fransua versus People. And we've got that set for an hour argument. Both counsel look like you're situated. Counsel for petitioners, why don't you begin?
Good morning, Justice Coates, Your Honors. My name is Rachel Mercer, and I appear today on behalf of Mr. Michael Fransua. The statute that governs this case is 18.1.3405, and it states that a person who is confined for an offense prior to the imposition of sentence for said offense is entitled to credit against the term of his or her sentence for the entire period of such confinement. This court has found that this statute gives a defendant the right to receive 1 day of credit for each day he's forced to spend in confinement while awaiting sentencing. And that is all Mr. Fransua is asking for in this case. He spent 272 days in the Pueblo County Jail and Pueblo County Community Corrections Program before he was resentenced to the Department of Corrections. But the trial court only gave him credit for 162 days of confinement. He asks this court to correct this error because each of the 272 days he spent in confinement represents punishment that he has already received for his crime. Now, there are two questions this court needs to resolve. First, is Mr. Fransua entitled to credit for the 108 days he was forced to spend in jail after he was arrested for violating the conditions of his bond? And second, is he entitled to credit for both the first and the last days of each of his periods of confinement? I'll start with the first question. To answer the first question, this court has to apply the test that it first set out in Schubert v. People. This case says that a person is entitled to pre-sentence confinement credit if there is a substantial nexus, meaning a causal connection between the charges in a case and a period of pre-sentence confinement. In other words, the confinement has to be attributable to the case. Now, in Schubert, this court found that test was not met because the defendant was seeking credit for time when he was confined on charges that were separate and distinct from the charge for which he was going to be sentenced. Here, this court should find that the test is satisfied because Mr. Fransua was forced to spend time in jail after he was arrested for violating the conditions of the bond in this case and the mandatory protection order in this case.
Ms. Mercer, can I ask you about that? And good morning to you. Thank you for braving the weather, all of you. So help me understand, maybe my question is going to go to what does substantial nexus mean? This would be an easier case for you if bond was revoked and literally Mr. Fransua was sitting in jail on both counts, but it wasn't. My fear is your argument feels a little bit like if there's any nexus, you count it as opposed to if there's a substantial nexus. So help me understand where the line is.
Yeah, in Schubert, this court said, was the confinement actually caused by the charge of conduct in the case for which the defendant is being sentenced? So it's basically, is there a causal connection? And it has to be a substantial connection. It can't be so indirect that it's, it's very weak. But here it's very strong. I would say here it is substantial. There's a direct connection between the charge in this case that he pled guilty to and his confinement. So what happens in this case is he was arrested in October 2013, I apologize, because and charged with burglary, harassment, and third-degree assault because he went to his ex-girlfriend's house and he entered without permission and he hit both her and her father. He then was released on bond on December 5th, a $5,000 bond on the condition that he not consume alcohol, not contact his girlfriend, and comply with the terms of the mandatory protection order, which restricted him from contacting her or visiting her house. On March 1st, he violated the conditions of that bond and the protection order by visiting her house, entering without permission, and refusing to leave while intoxicated. Without the charges in this case, without the bond in this case, the conduct on March 1st is not criminal. So here we have a really direct causal connection between the two. We have, without the bond, there's no violation of a bond conditions charge. Without the protection order, there's no violation of a protection order charge. And those documents also provide the basis for the third charge that he received as a result of March 1st, which is trespassing, because they showed that he knowingly and unlawfully went to her place because he knew that he was not supposed to be there. So these two cases
But you don't need we wouldn't have needed the violation of bond to have a trespass charge. He's not welcome in her house regardless, and he's there.
Yes, but it is coupled with, but here we have a really clear substantial nexus. And that's why I think this case is so clear and so much easier than other cases, because we also do have that violation of a bail bond charge, which just shows there is an inextricable link between these two cases. So the prosecutor also could have revoked Mr. Francois' release by moving to modify the bond in this case. But the prosecutor didn't need to do that because they had already effectively done the functional and factual equivalent of revoking his release by filing a charge for violation of the bail bond and holding him on that charge. This is just another way of doing the same thing. And the fact that the prosecutor took a different procedural route doesn't mean that there's not a causal connection between these two cases. The filing of a motion to modify the bond would have just been another option. Essentially, after March 1st, the prosecutor had a choice. When he was arrested, when he was detained at his ex-girlfriend's house and arrested, the prosecutor could have done nothing and allowed him to be released from confinement back onto his bond. The prosecutor chose to do something. They chose to take action by filing new charges alleging violation of the bond and violation of the protection order.
Ms. Mercer, what happened with the 413 case, the other case?
It was dismissed as part of a global plea agreement.
That's what I thought. Okay, so there was no opportunity to award the pre-sentence confinement credit in that case.
Correct.
And here we are.
Yeah, so there's no risk of duplicative credit here. If the prosecutor had actually chosen to take that charge to trial and he'd received a sentence and that sentence was consecutive to the one in this case, then he would only be entitled to credit in one case. But that case completely went away.
So would he be entitled to credit in that case?
Yes, he would also, because that is also a cause of his confinement.
So he would not get credit in this case?
If the sentences were consecutive, he could get credit in only one or the other, and the court would have to decide which one. But if the sentences are concurrent, then he should receive credit in both cases. But I think the fact that the prosecutor ultimately dismisses this violation of a bail bond charge highlights an important point. If this court accepts the state's argument and finds that there is no substantial nexus in this case, where the cases are so clearly related to one another, and one definitely leads to the other, and the prosecutor clearly wanted him out, did not want him to be out on bond anymore after March 1st, then it's going to be really easy for prosecutors to do an end run around the pre-sentence confinement credit statute and arbitrarily deprive people of credit. Because if a person's bond has to be formally modified, and that's the only way a person can be entitled to pre-sentence confinement credit, then a prosecutor is not going to have a motive to modify the bond. Instead, a prosecutor can always, every time a person violates the conditions of a bond, just file a new charge for violation of the bail bond, hold the person on that charge, and then if you don't want to go to trial on that charge, you can dismiss it. The person will not receive any credit in the original case. You've effectively broken the substantial nexus. I think that gives prosecutors too much power. I think it's not in compliance with the pre-sentence confinement credit statute, which was intended to give people credit for confinement that's legitimately related to a case. And therefore, I think this court should just recognize that what happened in this case is that on March 1st, the prosecutor chose to revoke Mr. Francois' release. The prosecutor did not think he should be at liberty anymore. He was returned to jail. He was unable to obtain release because he had to post more money. And he served an additional 108 days of confinement for which he has received 0 days of credit.
Was there any kind of a finding, good morning, was there any kind of a finding that the prosecution did this to try and skirt the requirement? Was there any factual finding about why they did that, or possibly was there a finding that they took that into account when they agreed to dismiss the count, that, well, he's already served 100 and blank days on this, we've got our punishment for it? I mean, it feels like we're kind of speculating as to motives.
There was not a finding that the prosecutor had an improper motive in this case. And I don't think there needed to be one to establish a substantial nexus because there's a causal connection. What I'm saying is there's a risk that a prosecutor could do that in any case because any bond violation, even drinking alcohol in this case, would be sufficient to provide a basis for a separate charge for violation of a bail bond provisions.
Correct me if I'm wrong, but isn't there a ramification if they revoke a bond with regard to how quickly the matter needs to be tried?
I am
I
not.
thought it accelerated if a bond was revoked, it accelerated the speedy trial. I haven't done that in a number of years, but.
That may be true. That's not something that I have researched. Looking through the bond statutes, I didn't see anything, and I didn't look at the speedy trial statute. I will say I don't think there's anything in the bond statutes themselves because I did go back through that.
Okay.
So I don't think they speed it up. Regardless, to your point about speculation, I don't think we need to speculate because in this case, we just look at what the prosecutor actually did, which is file new charges for violation of the bail bond. And which
Let me
indicates-
follow up on that. They filed new charges. So the question that was asked in Schubert is the same thing that we're asking here. Was the pre-sentence confinement actually caused by the charge or conduct for which the offender is to be sentenced? Wasn't he confined for the new offense? Wasn't the confinement actually caused by the charge or new conduct?
I think it was caused by both the new offense and the original offense because he violated the conditions of his bond and they wanted to revoke his release.
Okay, all right, thank you.
I'm still not quite, maybe I'm just missing here. Why wasn't he also confined for the trespass?
He was also confined for the trespass.
And so why do we need to address the question of revocation of bond as a separate claim? In this particular case, was he not confined on a completely separate offense, quite apart from revoking his bond?
Yeah, so two answers to that. One is under Schubert and the cases that follow it, Massey, Torrand, Johnson, there can be multiple causes of confinement. And I think in this case, there clearly were. There were old charges and there were new charges, and they were both causally related to his confinement after March 1st. And I think that you cannot say, the second answer is I don't think that the trespassing, you cannot describe that as separate and distinct. That is conduct that was in violation of the bond in this case. The bond is what made it clear that he was trespassing in violation, that he was not permitted to be at his ex-girlfriend's house. It's the same victim in both cases. It's the same charging jurisdiction. And it's possible they would not have even charged the trespass or believed that was such serious conduct were he not out on bond in this case and subject to a mandatory protection order. And here I would highlight in the suppressed documents in this case, we have the pre-sentence investigation report, which actually includes the officer's affidavit for his arrest on March 1st. And it talks a lot about this case. It talks about how, Mr. Fransua is out on bond and he's subject to a protection order. And I'm going to arrest him. I did arrest him for violating his bond, for violating his protection order. It doesn't talk about trespass. It shows that the confinement and the concern about Mr. Fransua after March 1st was clearly related to this case and to a concern that he might be a threat to public safety as mentioned and discussed in the bond statutes and that he needed to be returned to confinement.
Other than the trespass, kind of looking at it a different way, but for his new conduct, were there grounds to arrest him and revoke his bond?
I think that the new conduct is what provides the grounds for revoking
I
his bond.
understand, but they didn't. But I'm asking, other than his conduct of going over there and trespassing and violating the bond, were there any grounds under which they could revoke his bond that you're aware of?
There were no other violations of the bond alleged, so those are the basis for what could have been a motion to modify. And I think it clearly was a basis because the focus of the bond statutes is to ensure he appears for trial and to protect the public safety in the community. And this is clearly the kind of behavior that would warrant a motion to modify the bond had the prosecutor chosen to do that route. And I think it's just important not to give prosecutors the power to just, based arbitrarily on which procedural mechanism they choose to use to confine a person in jail, to break the substantial nexus when there clearly is a substantial nexus. These cases are inextricably intertwined with one another. One leads to the other. And again, the conduct on March 1st is, arguably all of it is not charged and not criminal without the original charges in this case.
What does Torres teach us about the situation, if anything?
I think Torres is distinguishable. It was a much more complicated case, I think, because it involves charges in multiple jurisdictions. It involves confinement in multiple jurisdictions. It involves a mental health confinement. at a mental health hospital. This is a much simpler case. Torres did state the test, arguably stated the substantial nexus test differently than previous cases, including Massey v. People. But I think that case is distinguishable, and that test stated in Torres should be limited to the facts of that case, to a multi-jurisdictional case, and not to a case involving charges in one jurisdiction, confinement in one jurisdiction. The entire time, Mr. Francois was held in the charging jurisdiction in the Pueblo County Jail. And so I think Torres has to be read narrowly in order to avoid it from being inconsistent with this court's other cases, Massey and Schubert, which say that you can have multiple causes of confinement if a person is held in a single jurisdiction.
Do you think in Torres, can you point to language in Torres that supports that, though? That it's intended to be limited to the multi-jurisdictional situation?
Yeah, I think, the way the test was framed in Torres, I think this court actually, unfortunately I deleted this from my notes, but this court actually said the question has already been answered, the question raised here has already been answered in Massey v. People, whether a defendant who's held in a different jurisdiction or in multiple jurisdictions, I believe it is. And unfortunately I don't have the pin site, but the question this court phrased in that case was about multiple jurisdictions, and then this court also talks about geography, and this court had some language about how the substantial nexus test is about causation and not geography, but it also acknowledged simultaneously at page 194 to 195 that although geography played a role in Massey and Freeman, so it is acknowledging that geography is still can be relevant when one is looking at the causation. So I think that Torres just needs to be read narrowly to avoid it from overruling, since it sided with approval, Massey and all the prior cases. It just needs to be read narrowly and can be distinguished from this case as a multi-jurisdictional case.
Can I ask you to follow up again, just about staying with the reason why these are connected
Yeah.
sufficiently in your mind? So if the defendant trespassed in somebody else's home and his bond were revoked for committing another crime, would you say the same, that he should get credit for both?
Yeah, I'm not sure there is a substantial nexus there. You've got different types of criminal conduct and different victims, and it's not related. And if the defendant isn't charged with a bond violation or accused of a bond violation, and if that wasn't a condition of the bond, I think it's a harder
He
case.
could still have his bond revoked and be charged with a violation of bond, couldn't he? If it were some.
Yeah, and I think if he is also charged with violation of a bond, then yeah, we've got a substantial nexus, because that's clearly an end run around modifying the bond. Or it's not necessarily an intentional end run, but it's just another way of modifying the bond. I think that then you have a substantial nexus if the prosecutor does that. But if you go out and you commit a completely unrelated crime, or if it's in a different jurisdiction, I think those are harder cases. And I think this is the case where there clearly is a substantial nexus because of the way the prosecutor charged it. The prosecutor made it fairly easy to see the connection between the two cases and made it clear that the prosecutor didn't want him to be out on bond anymore and didn't think that that was appropriate, and therefore created that substantial nexus through the prosecutor's actions. So if this court doesn't have any more questions on that issue, I can talk briefly about the first and last days of confinement issue. The second question is whether Mr. Francois is entitled to credit for both the first and the last day of his periods of pre-sentence confinement, and the answer is yes, because that's the only way to comply with 18.1.3405, which says that a person is entitled to credit for his entire period of confinement. The first and last days are clearly parts of his period of confinement.
Can you address, Ms. Mercer, Judge Miller's dissent below, where he said there's a way to harmonize both statutes?
Yeah, I mean, I don't think that there is a way to harmonize both statutes. The way I understood Judge Miller's dissent was there's maybe a concern about people receiving extra credit.
I didn't see that as I read it, and I'll just float this to you and get your response. He seemed to say the pre-sentence confinement credit is general, and it just says, you're entitled to full time, but it doesn't tell you how to calculate it.
Yeah.
So we look to that Article 2 statute to say how you calculate it, and that's how you harmonize them, as I understood his dissent.
Yeah, so I don't think that they can be harmonized because the word entire, as the Court of Appeals points out, means with no part accepted, whole, complete. And so if a person serves some time on their first day of confinement, because that statute just says when computing a period of days, you exclude the first day, but you include the last day. So it arbitrarily just deprives everyone credit for the first day of pre-sentence confinement credit, regardless of how much time they served on that day, even if they were arrested at 2 o'clock in the morning. I think that to arbitrarily deny that person credit would be inconsistent with the word entire. They should receive credit for that day if they were confined on that day. And that will result in maybe a couple extra hours, maybe a half a day of credit for time not served. But I think in the pre-sentence confinement credit context, due process and fairness requires this court to round up, to err on the side of caution, to make sure that everyone receives credit for their entire period of confinement and that people are not arbitrarily deprived of credit.
So how do we square that with other case law that says we can never have duplicative credit? I mean, it sounds like if you had a day where a defendant was transferred from one location to the next, and I'm thinking now like the multi-jurisdictional situation, if you're counting first and last days, you would require double counting of that transfer day, would you not?
Well, I think if the court was counting the days of pre-sentence confinement credit and allocating them to different jurisdictions, you could take that into consideration. Oh, this day is already in this period of confinement and this day isn't. So for example, here, Mr. Fransua was in jail and then he was transferred to community corrections. If a day is already included and counted in the community corrections calculation, then that maybe shouldn't be in the PSC, the pre-sentence confinement credit number. So you can like look at that when counting the days and just making sure that he is receiving credit for every day. That would be the mechanism there. I would say you just look at each day and see where it goes. The state makes an argument that because the DOC statutes say a person should be starting to serve their sentence on the day of sentencing, that a person might receive double credit for the day of sentencing. First of all, not everyone is going to be in a multi-jurisdictional situation, and not everyone's going to be confined through sentencing. And so I think it's unfair to arbitrarily deprive everyone of their first day of credit, regardless of the facts of the case, when there may be other ways of adjusting for that. But also, I think especially in the case of the DOC statutes, the state is reading them too narrowly because the Department of Corrections is charged with applying pre-sentence confinement credit, and there's no reason to assume that they're going to give duplicative credit if they realize that you've already received credit for the day of sentencing as part of your pre-sentence confinement credit, that is already allocated as time served on the sentence. Then they can start counting the sentence on the next day and say, okay, well, so that we have accounted for that day. You did get credit for serving your sentence on that day. Now we'll give you credit for the next day. There's no reason to assume that the Department of Corrections, when doing its job, is going to give out duplicative credit because it's charged with applying these credits in a way that is not duplicative. So I think there are other ways to adjust for that besides just arbitrarily depriving everyone of credit for their first day of confinement.
It's not arbitrary, though, right? It's because of, the computation of time statute. So
Yeah.
how is that arbitrary?
So, I just think that the computation of time statute doesn't apply here at all. I think if you look at the context of the statute, the purpose of that statute is to help a court to determine the deadline by which an action must be taken. So it says in computing a period of days. I think what it's clearly referring to is when a statute says something must be done within a certain amount of time. For example, the restitution statute says restitution has to be decided within 91 days of sentencing. So we have to figure out when does that 91 days end. And that's what section 24108 does. It helps you figure out when a period of time ends. It doesn't figure out how long something lasts, like pre-sentence confinement credit. And I think that's clear from subsection 3, which talks about when does the time period end and not about how long it lasts. And I think it's clear from subsection 2, which says that if the time period ends on a Saturday, a Sunday, or a holiday, you extend it to the next business day. That rule doesn't make any sense in the pre-sentence confinement credit context. So I think it just by its own terms doesn't apply. And the state asks this court to apply only subsection 1 and not subsections 2 and 3. But there's nothing in the statute that says only subsection 1 should apply. And it works with subsection 2. It says you include the last day, and then subsection 2 defines what is the last day. They're all together. And so this court should find that these statutes can be read in harmony with one another because pre-sentence 18.1.3405 applies to pre-sentence confinement credit, and 24108 applies to calculating statutory deadlines. And if this court finds that they do both apply, then I maintain there is a conflict between the statutes, and 18.1.3405 controls because it is both more specific and more recently enacted. So I think, in fairness, you just apply 18.1.3405 here and give a person credit for all of their confinement. So I didn't really plan to talk about issue 3 too much, the illegal sentence claim, because I don't think this court needs to reach it in this case. The Court of Appeals said that Mr. Francois' claim for the first and last days of credit could be raised under Rule 35A, but this is a direct appeal. And as the state concedes, Mr. Francois is entitled to relief regardless of whether Rule 35A applies. And because this is a preserved issue, Mr. Francois maintains, because he asked for pre-sentence confinement credit in the trial court, and also because he's entitled to relief under Rule 52B for a plain error. And so it doesn't change the outcome of this case, and it's obviously a complicated issue that the state argues also implicates Rule 35C. There's not a reason to reach it in this case. But if this court has any questions, I'm happy to answer them. Okay, well then I would, with your permission, reserve the rest of my time for rebuttal.
You may.
May it please the court, my name is Brock Swanson, attorney registration number 39116, and represent the people of the state of Colorado in this matter. The people's primary interest in this case, and the next one you're going to hear this morning, is in the impact of an incorrect calculation of pre-sentence confinement credit on the finality of a judgment of conviction. Regardless of how this court resolves whether the first and last day of each period of confinement should be included, many cases will have been calculated incorrectly. And in Torres, this court also recently clarified the standard for awarding pre-sentence confinement credit so that many defendants may have had too much credit noted on their minimuses. The people respectfully ask this court to resolve how the finality of all those cases where the process is flawed will be affected. And because the defendant really didn't, or asked this court not to address the issue, I'll give this court, I think, 3 reasons why it should address that in this case or the next case or another case it's issuing at the same time. And the first is that it is at issue in this case. Whether pre-sentence confinement credit is an illegal sentence impacts the standard of review, which is the threshold issue in addressing every appellate claim. And second, it was actually addressed by the Court of Appeals in this case. And that holding remains the law binding on the trial courts unless and until this court addresses the issue. And the third is that because of the scope of the impact on the ruling on the merits and the number of cases that it potentially affects, this is an area that the trial courts need guidance about the appropriate procedure for correcting pre-sentence confinement credit and its impact on the finality of the case.
Let me ask you, Mr. Swanson, good morning to you. I understand your argument, and I think the issue, the 35A issue, is squarely presented in the next case we're going to hear. I do understand, I think this case was published in the Court of Appeals, if I recall.
That's
Why couldn't we, I mean, and you concede they didn't have to reach it in their case. Could we not, in an opinion, vacate that portion of regardless of what we do in case number 2 here, just vacate the 35A discussion and deal with it that way? I understand your concern that there's a published opinion out there that you disagree with. Why couldn't we just do that rather than reach an issue that I think everyone agrees doesn't have to be addressed in this case?
There is another prior published opinion, which is People versus Roy, which is out there, which says that this is an illegal sentence claim. And then there's the next case you're hearing here. So I think that it is important that this court address it in one of those cases.
Yeah, and I agree with you. I'm just trying to figure out, in this case,
Sure.
where we just say, there really isn't any reason to address it, could we not just say we vacate the discussion of 35A in this case, regardless of what we decide on the other issues? Could we not do that?
I think that you could. You could do that. But the people's interest is that you do address it at some point in the near future.
Thank you.
But you could not do it. I am going to, if this court allows me, present our argument regarding those issues. But if this court wants to address it in another case, that is, I think, acceptable in this
Yeah,
case.
and I didn't mean to foreclose you. I just was curious what we would do if we didn't want to go there.
There are a number of ways that this court could hold that a finding of the amount of pre-sentence confinement credit, while subject to correction within reasonable timeframes, does not affect the finality of the conviction. And the most fundamental, I think, is to hold that the finding is not part of a defendant's sentence within the meaning of the rules of criminal procedure, and thus is not subject to correction under CRIMP 35A. A sentence is the punishment imposed for a crime. It is a legal conclusion about the appropriate penalty for the defendant's actions. Pre-sentence confinement credit is not punishment. It is a factual finding that, along with a number of other factors, is used by the Department of Corrections to determine things like the defendant's parole eligibility and mandatory release dates, given all of the sentences that have been selected by the trial court in however many cases the defendant happens to have convictions. Consistent with that distinction, the rules of criminal procedure list the finding of the amount of pre-sentence confinement credit as a separate component of a judgment of conviction. I think the very nature of CRIMP 35A confirms that it is not the appropriate provision for addressing pre-sentence confinement credit, because unlike CRIMP 35C, there is no procedure in CRIMP 35A for holding a hearing to make factual findings. But because pre-sentence confinement credit is a factual finding, a claim that the finding is wrong could often depend on cases, on facts outside of the record. For example, in the next case you're going to hear, it was about a period of pre-sentence confinement credit that he'd spent in another jurisdiction that the court was not aware of when it was awarding pre-sentence confinement credit in the initial sentencing. In many cases, the trial court accepts whatever number is calculated by defense counsel or is listed on the PSI, pre-sentence investigation report, without any inquiry into the underlying facts supporting that calculation. If a sentencing court properly applies all of the statutes to the facts presented to it at sentencing, it should be able to impose a final legal sentence. But under the Court of Appeals interpretation, that is not the case. The sentence can be illegal because of some fact outside of the record about which the sentencing court had no knowledge. Because the finding of pre-sentence confinement credit is not part of a defendant's sentence, the defendant's claims are not claims that his sentence was not authorized by law.
Mr. Swanson, I'm sorry to interrupt you again. Could you remind me, did the Court of Appeals here raise the 35A issue on its own in its opinion? Was it addressed in argument or in the briefs before the Court of Appeals?
It was not. It was, we said plain air, and then they put that in there. But I think that, to me, is the reason why, and I definitely will get to the merits of the claims. But
Yeah, and I'm just trying to think what our standard review is, were we to reach it in this case on the government's position here. Was it a 35A motion? What was the, below, what was?
this is just a direct appeal from the sentence.
That's right, I'm sorry.
Yeah,
That's
no,
right,
sorry.
that's right. I'm getting my
Yeah.
cases mixed up myself. All right. And so the government, I guess your position has never had any opportunity to address this 35A issue because it came up for the first time in the opinion?
That's right.
Okay, thank you.
In the alternative, I'll briefly touch on, even if the finding of pre-sentence confinement credit is part of a defendant's sentence, we would say that any error in the finding still does not result in a sentence that was not authorized by law. This court should hold that a sentence is not authorized by law only if it could not have been reached regardless of what occurred at sentencing. That is, if the sentence imposed is a sentence that is not within the realm of possibilities for a given offense. If the sentence could have been reached by some proceedings at sentencing, then a challenge to the outcome of that sentencing proceeding necessarily challenges the legality of the manner that the sentence was imposed. And any broader interpretation than that, I think, would swallow the illegal manner claim that is also under CRIMP 35A. So under that framework, a challenge to the trial court's factual finding of the amount of pre-sentence confinement credit noted on the minimus is a claim that the sentence was imposed in an illegal manner and not that it was not authorized by law. And if that was the case, that would still permit the plea bargaining framework that was set up by Schubert and has been used in countless cases since that, because illegal manner claims are claims that are subject to waiver by through the plea bargaining process. That they're actually specifically included in the propriety claims that are waived if you're sentenced within the range that you have agreed to as part of your plea bargain. And then in the next case, you're going to hear a couple other ways, even if it is an illegal sentence claim, that it may not impact the finality, and I'll leave those for the arguments there. Are there any other further questions on those issues in this case? I do want to emphasize that is our primary interest in this. As far as the merits in this case, our interest is mostly in clarity, that whatever amount of pre-sentence confinement credit the General Assembly intended the trial court to note on the minimus be clearly defined so that it can be done correctly. Turning to the first and last day issue, here the General Assembly has expressed its default intent for calculating time in the general time computation statute. And when it wants to do otherwise, it has done so with a specific statute, like it did for M8 and parole time computation, where it has a statute says computation of time and then gives a different standard for addressing that.
So can I ask you on this one,
Sure.
Mr. Swanson? I had the same concern that Ms. Mercer raised. I think you concede 24108.2 does not apply in the pre-sentence confinement context. How do we say that half the statute applies to pre-sentence confinement? It strikes me as kind of odd.
So I would say that the statute expresses the General Assembly's general intent about computation of time periods, and that is going to apply in a number of different circumstances, and it applies to the extent that it does. So those provisions specifically talk about the extensions of time periods. And so I think by their terms, they apply to time periods when an extension is possible.
But could you not say, since you can't, and you agree, really it doesn't make any sense to apply 108.2, so this statute doesn't apply at all to pre-sentence confinement credit, therefore look to the pre-sentence confinement statute. Why isn't that right?
I think that because it is a general provision that is not tailored to any specific context, that it is reasonable to interpret their intent in this statute to be addressing a number of different contexts, but that it should be applied to the extent that it
I agree, but you could feasibly apply subsection 2. That probably makes no sense. You could apply subsection 2 physically. There's no reason you couldn't. It doesn't make any sense, but you could do that. I could see a situation on your argument where there's no way to actually do it. Here you could do it. You could say we're not going to include weekends.
I don't think you can because it uses the word extends. And when you're calculating between two dates, there's no room for an extension.
Okay.
If that makes sense.
It
So
does.
that the extends language is specifically tailored to a deadline calculation, and that it would apply in that context, but not otherwise.
But doesn't that suggest that the entire provision pertains to calculating deadlines in terms of determining what is the end of that period?
I mean, I think that it is a general statute, and the first provision of it does not say anything about deadlines, and it would appear on its face to apply to the calculation of any periods of time. And that's the provision that we're asking you to apply as a general expression of their intent, absent any other expression in the statute.
So subsection 1 on its own might be true, but read in conjunction with subsection 2, that last day. I think subsection 2 just adds some clarity to subsection 1, does it not?
I don't know that you can read that intent into this because it is not tailored to any specific context. It's just a general expression of our intent generally with regard to how you're going to be interpreting things in the rest of the statute, and that they apply to the extent that they apply. And I'd also just note, This is just because we don't have an answer and we're looking for intent somewhere else. So even if it doesn't apply by its straight terms, I think it is a expression of the General Assembly's general intent about how time periods should be calculated in the absence of other direction.
Why don't we have an expression of the legislature's intent in the statute that provides that credit will be given for the entire period of confinement?
Sure. I think that the word entire is ambiguous. It does not answer the question about how we're going to be calculating these time periods. And specifically, I think the entire is directed at, in the context of pre-sentence confinement credit, that the practice prior to that permitted granting partial grants of pre-sentence confinement credit. And it still does in context where there's not a statute, a statutory right to pre-sentence confinement credit, like when a jail is imposed as a condition of probation. You can give partial grants of pre-sentence confinement credit, saying, I'm giving you were confined for 40 days, but I'm only going to give you credit for 20 of those. And so the meaning of the word entire here is to say that you need to give them credit for all of the days. We're taking away that discretion to deny or to give partial credit for pre-sentence confinement credit. The other argument that I think informs the whether he should be given credit for the first and last day is that the Court of Appeals interpretation generally means that a defendant who posted bond would serve one more day than a defendant who would not post bond and was confined through sentencing. And I could do a simple hypothetical to illustrate that difference. Let's say you have a defendant who receives a 7-day sentence. If defendant 1 began pre-sentence confinement on Monday and was sentenced on Wednesday, he would complete his sentence on Saturday, serving no more than 6 days, because Wednesday would count twice. It would count both as a period of confinement, noted as a period of confinement, and it would be the first day of his sentence under the specific time computation statute that we have for sentences. Conversely, a defendant who is not confined prior to sentencing, if he was first confined at the same time on Monday as the other defendant, he would not complete his sentence until Sunday, which is a day later than the other defendant. And I think that can give some clue to the General Assembly's intent that they probably did not intend that result, that there be a double credit in this situation.
Doesn't that articulation assume that whether it's DOC or ComCorp or whoever tracking the PSCC would not take into account that duplicative credit on that transfer day or change in, I'll call it a transition day, right?
Right. And that's correct. And that's actually, I heard defense counsel say that, and I have not checked into whether that is what their practice is with regards to whether they are taking that into account or not. But if this court does award both, it would be helpful if the court gave guidance on whether the Department of Corrections should do that or not for future
Fransua?
cases.
Sorry. Good morning. Let me take you back to 24108. If you were filing a brief and you were trying to figure out when the brief was due and you had a 14-day deadline, would you be able to figure that out just by looking at subsection 1, or would you also have to look at subsection 2?
I think you would look at subsection 2 because it's a deadline, and by its terms, subsection 2 applies to things that are subject to an extension, which a deadline would be.
So in that case, you would look at both subsections.
That's right. That's right. And I would note, we're making this argument because I've seen many trial courts relying on this and making their determinations of pre-sentence confinement credit. And so we're presenting the issue to be resolved by this court, which what should be the appropriate. We don't have a strong interest in whether defendants receive 1 day or 1 day less. I don't want to overemphasize that point.
You say you see it happen a lot.
Mm-hmm.
In my experience, the trial courts aren't even really having to do any computation because the parties stipulate to what the number is. And so tell me what you mean by a lot. How often? I mean, I see that we have some cases that have percolated up through the Court of Appeals, and that's why we're here. But frankly, I was a little surprised because I can't remember in all the time that I was doing this at the trial court level ever having to contemplate using the Title II statute in order to figure out pre-sentence confinement credit.
And I think that is exactly the point. I can't quantify the magnitude necessarily, but the point is that it hasn't been thought of, and they've been doing it just, we don't know how they've been doing it. They've been doing it different ways. I tried to look back through different cases, published cases we have, and to the extent they have dates, and some of the numbers that are approved are including it, and some are not. If you just use like in your, in Windows, there's a built-in date calculation calculator. That is not including both the first and last day. That's just the default that's in there. So as it is now, it's just been subject to whatever happens to be the calculations. And I think that really gets back to our primary interest is in finality, because this has not been something that's been carefully looked at, and we're going to have to go back and check all these. If this is an illegal sentence and affects the finality of convictions, and we don't necessarily even have all of that information in our records to determine whether this first and last day has been included in each of these calculations. I know I have, just when I've been doing pre-sentence confinement credits inside there, I had just, up until we had Houston, I have been not including it because that's what the default is in these different calculation tools that you use for doing pre-sentence confinement credit, and that's comported with a number of, most of the cases that I had seen up until that point, what the trial courts had awarded and calculated. There are no further questions on that. I'll turn to the parole issue. I think under any reasonable interpretation of the pre-sentence confinement credit statute, a defendant is entitled to credit only for confinement that was actually caused by the offense that the defendant is being sentenced for. That's the limitation that's in the statutory language. In other words, a defendant is not entitled to credit for any period where, if only the sentencing charge existed, the defendant would not have remained confined. And here the defendant would not have remained confined during the period he now seeks credit for if only the charge he was sentenced on existed, because he had posted bond for that offense and that bond had never been revoked or otherwise modified to prevent his release. Thus, under any of the opinions that were expressed in Torres, the defendant was not entitled to credit for that period in this case. Moreover, under the majority opinion in Torres, a defendant must show more than actual causation to be entitled to the credit. He must show that if the sentencing charge did not exist, he would have been released. And the defendant cannot make that showing either, as the charges in the other case, particularly I think as we talked about the trespass, totally unrelated trespass, would have prevented his release even absent the charges in this case. I'd also note that the defendant's situation here is not a new one. Shortly after the right to pre-sentence confinement credit was created, this court recognized in Schubert that there will be cases where charges where pre-sentence confinement credit would have been awarded by the statute would be dismissed as part of a plea deal. And it held that those would appropriately be the subject of plea negotiation. And that has been the practice since then. And the defendant here got everything he bargained for, and there's nothing unfair about that. The trial court, when it was addressing this argument in the trial court, specifically noted, I don't have anything in the plea bargain saying that you should receive this credit, and so in the absence of that, I'm not going to be awarding credit. That has been the practice that this is a subject of plea negotiation. And the defendant had an avenue to try and secure this credit, but did not in the plea negotiations. Let me see here.
Could you respond to,
Sure.
or respond to your opposing counsel's thoughts that Torres is limited to the multi-jurisdictional context?
I think that is inconsistent with Torres's language indicating that it was rejecting any sort of geographical limitation, that it was taking causation. I do agree that that had been the law prior to Torres, that there was a geographical distinction, but I think that was rejected by all of the opinions, basically, in Torres. Well, you guys know that better than I, but that the geographical limitation is not consistent with the statutory language that we currently have. And I think that it's not been retained in the current formulation under Torres.
Let me ask you also then to address this argument that the charge for violating bail bond conditions effectively took the place of a modification of the original bond.
I think that there are very real differences between those procedures. That the defendant was in a situation where he does not have to post bond in this case in order to be released. He only has to post bond in the other case in order to be released. And if there had been any sort of modification or revocation, then he would be in a different situation where he would have to post bond in both cases in order to be released. So it's not just an illusory distinction, but there are very real and strategic considerations to be made regarding those two different situations. There are no further questions? Thank you.
You.
I kind of want to go in reverse order and start with the substantial nexus question for the 108 days of confinement. And just note that under the substantial nexus test, you don't have to be formally held and have your bond formally modified and revoked in order for there to be a substantial nexus with a case. It just needs to be causally related, and I think there clearly is a direct and causal relationship. I also want to note with regard to the discussion of the plea agreement, that is not the question here. The question here is not whether he could have gotten credit under a plea agreement. It is whether he was entitled to it under the statute. Because the rule that this court announces today will apply in cases where a defendant takes his case to trial and has no opportunity to bargain for credit for time that is legitimately related to his charges. On the first and last day, on the Torres question, I just wanted to say that the pin site I was looking for was page 193. This court posed the question as follows in Torres. They said, in Massey, we face the precise question we confront today, where a defendant has been confined on offenses from multiple jurisdictions, to which case should that pre-sentence confinement be credited? So arguably, you could read that as a multi-jurisdictional case. With regard to the first and last days of credit, the state appears to concede that when the DOC is calculating time served for time actually spent in the Department of Corrections, they do include the first day. The same rule should apply to pre-sentence confinement credit because it is part of the time served on a sentence. This is not something that is subject to the general time computation statute that was not intended to address this situation, and that was in fact passed 6 years before pre-sentence confinement credit became mandatory. With regard to the 35A issue, I want to make it clear that Mr. Francois does maintain that this would be an illegal sentence claim, that that would be another avenue for raising it that just doesn't need to be addressed in this case. I don't believe that the government filed a petition for a hearing in the Court of Appeals, but the Court of Appeals did raise that issue on its own. We briefed it as plain error or preservation, as Mr. Francois maintains his claim was preserved in this case. I think it's clear that pre-sentence confinement credit is part of the sentence in a case because it's part of the time served on a sentence. It is part of the punishment that a person receives for an offense. It is not a bonus credit. It represents actual confinement. And the pre-sentence confinement credit statute is found in Title 18, Article 1.3, Part 4, which is titled Sentencing in Criminal Cases, and specifically sentences to imprisonment. So I think it is part of a person's sentence. It's part of their punishment. And what Mr. Francois is raising here, to the extent I can address a specific question, When he's requesting the first and the last days of credit for both of those days of confinement, it's not an illegal manner claim. He's not claiming that the court used the wrong procedure to reach the result in this case. He is claiming that the result is inconsistent with the statutes because he's entitled to credit for the entire period of confinement, and it is undisputed that he was in confinement for certain days, and the court said it was going to give him credit for those days, but did not give him full credit. It denied him at least 3 days of credit with regard to that issue. So there's no factual question here, and I would say that in most pre-sentence confinement credit cases, there's not going to be, because the government keeps pretty good records of when and where it confines people. So mostly these cases are going to involve questions of law as to whether or not you have a statutory entitlement to credit. And so again, Mr. Francois is just asking for credit for all 272 days that he was forced to spend in confinement because he has already received some of the punishment for his crime, and so his sentence should be reduced by that amount. And so if this court doesn't have any more questions, I would just ask you to affirm in part and reverse in part the Court of Appeals.
Thank you very much. I'd like to thank both counsel for their arguments. The case will stand submitted, and the court will be in recess for 15 minutes. Thank you. Please be seated. Next case on our docket this morning is styled People v. Baker. We've also set this one for 1 hour. For those of you that didn't have an opportunity to get near a window, I will offer the latest weather report. The rain has changed to snow and is coming down sort of horizontally. But you all look like you're ready. Mr. Kozalewski, why don't you begin?
Morning, may it please the court. William Kozalewski, registration number 37824 on behalf of the people. This case presents two related questions. First, whether pre-sentence confinement credit is part of the sentence, or is a claim that a sentence is not authorized by law under Rule 35A. And if it is, then did the legislature intend for a final conviction under 16SC508 to not occur until the finding on the minimus regarding pre-sentence confinement credit is precisely correct? Our answer to both of those questions is no. And I'm going to start with the second question, mostly because Mr. Swanson dealt with most of our arguments as to why pre-sentence confinement credit is not part of the sentence.
Mr. Kozalewski, before you jump into the merits, could you address what the standard of review is here? I think there's an argument that the government didn't preserve this 35A, so we'd be reviewing for plain error. I mean, on the 35A, not only the government didn't object, conceded it on the pre-sentence confinement credit. Likewise, on the Levia issue, I'm just not sure how, if it was preserved. I'm really just trying to figure out the standard of review.
I mean, I think all the issues today are pure legal issues. I don't think so. That standard of review. As far as preservation, the initial pre-sentence confinement credit motion was conceded, but I don't think there was any argument over what provision of the rules that was brought under.
Sure, right, and I'm not fencing with you. I'm
No,
really
right.
just trying to figure out. So they filed under 35A. The government never said that's not the right mechanism. And does that create a standard review issue?
I don't think so, because our argument is that whatever happened in granting that credit, it didn't affect the finality of the judgment, and that our current argument is this current motion is untimely under 16SC508, which the legislature has specifically authorized appellate courts to address for the first time on appeal.
All right, and I do know the statute you cited. Did the government argue it was untimely below?
No, our position was that it was a 35B, and the court agreed with that. So it's one of those where we shouldn't, I would argue, we shouldn't have to make an alternative argument when the judge rules in our favor.
All right, got it. And sorry to take
No,
your
that's
time on
fine.
that. Thank you.
So I essentially would like to start with the Leyva issue. And I think it's important to flesh out what exactly was involved in Leyva. He pled to 3 charges, and he received an illegal sentence on one of those charges. Several years after sentencing, he filed a 35A. They corrected the one sentence. A few years after that, he claimed that his attorney failed to investigate the proper maximum sentence for the charge that he received an illegal sentence on, and that his attorney failed to properly advise him on the proper sentencing range for all counts. And this court was our position that that motion was untimely, and this court said, no, it wasn't, because under 16SC508, the term conviction meant a valid final determination of guilt and sentencing. And this was to bring it into accord with Hampton that said a conviction isn't final until a direct appeal is exhausted. So the Court of Appeals in this case is correct. There was some broad language about this court's holding, but there is also some language supporting our position. And that is the language where this court said that its conclusion comports with the purpose of 16.5.402, that defendant should be allowed to pursue any good faith argument for post-conviction relief, addressing, and this is the important part, how that illegality potentially affected his or her original conviction. And it specifically noted that the defendant in Leyva asserted that his illegal sentence helped establish his ineffective assistance of counsel claim that was in his 35C. So it's our position that by its own terms, the analysis in Leyva only applies to claims related to the illegal sentence. And I would ask you to adopt the reasoning in the recent unpublished opinion that I provided to this court that came out a few weeks ago from the Court of Appeals. And that is, the time period is only reset for claims that are somehow related to the illegality in the original sentence and how that potentially affected a defendant's original conviction. And I think the main argument to that is that Leyva should be read to be as consistent with 16.5.402. And the purpose of 16.5.402 is to avoid litigation of stale claims. So the question under Leyva is the claim that the defendant is currently making a stale claim? Because everything else will be encompassed under justifiable excuse and excusable neglect. If a defendant has a good reason to bring a claim late, there is a provision of the statute that allows him to bring that claim.
Given your articulation of the limitation you would like to impose, and given that, I would assume then the argument here is the SVP designation has nothing to do with pre-sentence confinement credit.
Correct.
What if the claim, the 35C claim, is an ineffectiveness claim that you failed to challenge my pre-sentence confinement credit?
That would fit within my rule.
Okay.
And sorry, so that would
No.
mean the time does get reset, fit within your rule, or doesn't?
If the claim, if you, well, it's kind of, as I understood Justice Marquez's question, he would have already gotten relief. If you conclude that a pre-sentence confinement claim is an illegal sentence, and he gets that credit. So I guess Leyva is the example that I would say where the sentence was illegal and then a defendant says, now that I have this illegal this sentence corrected, I can now claim ineffective assistance of counsel. He almost didn't have the claim before his sentence was corrected. Because if his sentence was legal, then his ineffective assistance of counsel claim disappears. So I think Leyva dealt with a small set of claims that are not encompassed within justifiable excuse and excusable neglect. And that is consistent with the purposes of the statute that want to avoid the litigation of stale claims. And I think this case is a good example. The defendant found 18 days of pre-sentence confinement credit that was just overlooked at the sentencing hearing. And that has nothing to do with the validity of his conviction and his claim here in the SVP. There's no dispute that he could have brought it any time within the initial 3 years after his first sentencing hearing. The law was there, he could have brought it. So I don't think there's any dispute that this would be a stale claim within the meaning of 16.5.402. So if Leyva is read to reset the time bar as to all claims on the judgment, then that's just simply a windfall to a defendant who is late. And as we've argued in the brief, the incentive to hold on to a small portion of pre-sentence confinement credit until you have a claim to bring under 35C that you think is a winner is a real risk. And that does happen. It was as an example, it was a restitution case that was recently published. But we've had several claims now where the restitution amount was 0 and it's just not on the minimus. And the defendant says, well, you didn't put restitution on the minimus, it's 0. Now the time bar is reset, here's my 35C. And that result is just completely contrary to the purposes of 16.5.402. And to follow up on that, I have a case on my desk right now where the defendant, the crime was in 1986, and he's claiming that they didn't do restitution and they didn't seek restitution, but it's not on the minimus, so his sentence is illegal. And he's not doing that just to get 0 on the minimus, probably. And even if LEVA does reset the time bar as to all claims, it is our position that a claim for pre-sentence confinement credit under 35A should not reset the time bar in and of itself. And that is consistent with Dunlap, the Court of Appeals. Once again, that was restitution. But under 35A, it says may, and it is not for this court to circumvent the intent of 16.5.402 in saying that, okay, pre-sentence confinement credit is an illegal sentence claim, but if you are even one day off, and as demonstrated by the argument this morning, I think, it's not always clear how much pre-sentence confinement someone should get, and it is not the product of the parties not wanting to get it right, but several years later, it may be wrong by a few days here and there, and that should not affect the finality of the judgment of conviction, dealing with the underlying validity of the jury verdict or the plea, where it is, like in this case, the judge asked how much pre-sentence confinement credit there was, the parties gave him a number, and that's what he got. If someone had told him that there were 18 days sitting out there, he would have given it. So I think, and that kind of circles back to our why it's not part of the sentence, is, and Mr. Swanson touched on this, I think this is more of a practical argument, but a trial judge, his or her, one of his biggest responsibilities is to impose sentence. And part of why an illegal sentence can be raised at any time is if a judge says, what's the range, and the prosecutor gives his answer and the defense attorney gives her answer, the trial judge has an independent responsibility to open the statute book, know what the offense is, know how all that works, and impose a legal sentence. And under the defendant's position of how this works, at this sentencing hearing, the trial judge could not have imposed a legal sentence. It was impossible because no one knew there were these 18 days sitting out here.
Let me take a step back and have you talk about why it's not part of the sentence. And my question is, what is the proper vehicle, in your view, for challenging pre-sentence confinement credit if it's not 35A?
It would just be a 35C. I think this case is
What language in 35C do you point to supporting that? Because I'm not seeing it, at least off the top of my head, but
Well,
maybe you can point me.
I think the analysis would be the same as the Court of Appeals in concluding that the SVP in this case can be charged under 35C. The last provision of 35C is, or any, I'm paraphrasing here, or any other basis to challenge a judgment of conviction. And under 32B, you have the things that are listed as part of the judgment are the verdict, the sentence, the amount of pre-sentence confinement credit, and sex offender findings, restitution, there might be one more. But so just as the Court of Appeals in this case held that you can challenge your SVP under 35C because it is part of the judgment, pre-sentence confinement credit is part of the judgment just as well. separate part.
So what do you do about Massey and Freeman? Those cases have been on the books 32 years. They were both 35A motions relating to pre-sentencing confinement credit. I understand your principal concern is leva in this resetting. So help me understand, do we have to overrule those cases? And I recognize they didn't directly address 35A. They just kind of assumed that was the right mechanism and no one challenged that. So address those cases and tell me why this wouldn't be a sentence unauthorized by law. I mean, if the court doesn't say, gives no pre-sentence confinement credit, which the court's required to put on the minimus, the defendant does more time.
Okay. Let me take those in reverse order. I think if a court said, as was in Dunlap, if the court doesn't do pre-sentence confinement credit at all, then I think that's closer to a pure 35A claim, assuming it's part of the sentence. But as to Massey and Freeman, I agree. My first argument is that wasn't dealt with. And I think both of those cases were, I think one of them was a direct appeal, and one was a 35A filed within the timeline of an illegal manner claim, and that's our secondary argument, that it would be an illegal manner claim. But I think to prove the point, I think Schubert was they filed it under 36 for a clerical error, and I'd submit that was not a clerical error claim in the sense of, oh, we just forgot, we transposed numbers, or we forgot some days. It was a substantive claim like it was this morning in the sense of, I'm entitled to this credit as a matter of law. So my position is this court has never addressed this question head on.
Okay, thank you.
If we say it's a 35A illegal manner claim, then it has to be filed within 126 days. Is that right?
Right.
If we say it's a 35C claim, then there would be more time to file at 3 years.
Right. Yeah, and our first position is that it's 35C because it fits within the rules better as that, because the main argument on why it's not part of the sentence is a statutory language in the sense of the statute itself says it's a credit against the sentence. So by definition, it's not part of the sentence.
How is it part of the criminal judgment, though, for purposes of 35C?
The statute says that the court shall note the finding on the minimus, and then this court's rule in 32D says it is part of the judgment. The finding of pre-sentence confinement credit is part of the judgment. I don't have much else unless someone has. Sure.
That made me think of a question. So I think you said, and I don't have 32D in front of me, but I think did you say earlier that would include also restitution?
Yeah, at 32B lists the verdict and findings, restitution, pre-sentence confinement credit, the sentence, sex offender findings, costs. There might be one other.
So the reason I'm asking that, it sounds like you're saying, well, you see right there, it says pre-sentence confinement credit, and it lists that as separate from a sentence. But it appears to do the same thing with restitution, and yet I think it's decided that restitution is a component of the sentence.
Yeah, the Court of Appeals has had that, and I think this court has, if not explicitly held that, implied it. And I think the answer to that is restitution has a punitive component to it, and this is exactly the opposite. It is a credit that the person is going to spend less time held by DOC after the sentencing hearing.
But it does reflect the time they're going to serve. I mean,
Absolutely.
the absence of credit is actual days in somebody's life.
I don't disagree with that. I totally agree with that. And I think, and maybe it's a matter of semantics, but Mr. Mueller in his brief said a person sentenced to 4 years in prison has a sentence of 4 years no matter the pre-sentence confinement credit. I totally agree with that. You would never, his sentence isn't 3.5 years with 6 months pre-sentence confinement credit. His sentence is 4 years, and he has 6 months of pre-sentence
But
confinement.
the absence of an award of credit to which the defendant is entitled means it's 4 years plus, which I assume Mr. Mueller's argument is that makes it an illegal sentence.
I guess my response to that is the sentence is something under the statutes that is imposed on a defendant. When he gets out is a function of many variables that the legislature has put in. And I think to illustrate that point, the familiar passage that trial judges are supposed to say after sentencing in 18.1.3.404.2a, quote, and they're supposed to say this verbatim, I believe, the defendant may spend less time incarcerated than the terms announced here today. The actual time served will be influenced by a number of factors, including but not limited to previous criminal activities, eligibility for earned time for good behavior, correctional earned time, credit for time served, or community corrections eligibility. And I think if someone, I mean, I've had cases where someone has been in confinement longer than what their sentence is, and it makes no sense to say he had no sentence or his sentence was 2 years of pre-sentence confinement credit. His sentence was 2 years. The legislature has recognized that people should get credit for serving that sentence before the sentencing hearing, but that doesn't make it part of the sentence. With that, I'll reserve the balance of my time. Thank you.
Good morning. May it please the court, Adam Mueller on behalf of Mr. Baker. Notwithstanding Justice Gabriel's note at the prior argument that the issue is squarely before the court, I'm going to take a stab at convincing you all otherwise, as I did in my brief, but I promise I'll keep it brief. If the Attorney General is right that a pre-sentence confinement challenge can only be raised collaterally, that is, under Crim P 35C, I disagree with that. But if that's right, then Mr. Baker should have been appointed counsel when his motion was originally filed, his first motion, because that's a 35C. It had arguable merit. It had more than arguable merit. Everyone agrees he's entitled to 18 days of pre-sentence confinement credit, and under 35C.3.5, the district court should have appointed counsel, should have referred it to the public defender's office for appointment of conflict-free counsel, who could have then investigated and amended the complaint or the 35C petition to raise additional claims, including the challenge to the SVP designation, which now everyone agrees was erroneous, and that would have been raised, and he would be entitled to his new hearing. So I'll leave it at that because I do want to get to the merits, but I think no matter how the court cuts it here, and I think this speaks in part to the fact that Justice Gabriel raised as well about preservation. I didn't ask for plain air review. I've not seen plain air review in the context of an appeal by the government, but I do think the government's concession at the original hearing that this was a 35A motion properly brought and that the defendant was properly entitled to 18 extra days should have some effect. It would have effect if the sides were reversed. If we make concessions, those things have consequences, and they should here as well. Notwithstanding all that, I want to turn first to the big picture, which is really why I think we're here. We heard it from Mr. Swanson and from Mr. Kozlowski as well. The government's primary concern is LEVA, because the government paints a picture of gamesmanship by defendants. And with all due respect, that's a fantasy. There is no evidence of that. And while I certainly don't doubt Mr. Kozlowski's word about the cases on his desk right now, and I've had cases that do this, none of that is in this record. That should not influence this court's decision. I don't get to go outside of the record and talk about my experiences on cases that are unpublished or currently pending before me. I couldn't, consistent with my ethical obligations to keep attorney-client confidences, so I don't think the court can be influenced by that. So I want to talk about why this is a non-existent problem and why if the court accepts the government's view that 35C is the correct mechanism, it's going to create tangible, real, and unfair problems. So why is it not a problem to raise pre-sentence confinement credit under 35A. There's no evidence of a parade of horribles that the government contends exists. Roy, which is the Court of Appeals decision which first announced that you can raise these claims under 35A, was decided in 2010. Leyva was decided in 2008 by this court. Far as I know, this case is the first that I'm aware of, if we're going to talk about our experiences, this is the first case where someone has raised a pre-sentence confinement challenge and then had the statute of limitations renewed. But certainly there isn't any evidence in the briefs pointing out to a parade of horribles here. And I think there's tons of reasons for that. The first being, no one I've ever represented wanted to stay in custody a day longer than they needed to. Once someone has a viable 35C claim, they raise it. I have represented tons of criminal defendants where they have wanted to get out as fast as they can. Criminal defendants who are in custody are not often shy about litigating claims. I don't think there's a real incentive for defendants to sit on their hands when they have a viable claim.
Well, Mr. Mueller, let me ask you, I mean, that may be right, and, I bristle a little too. There's a strategy on a defendant's part to sit in jail and not raise something. I question that premise. But is there any limit to Leyva? I mean, put the parade of horribles aside. I mean, it may well be as somebody sitting in prison for a long term and they're getting at the end and they start looking at their parole eligibility date and whatever else, and they say, gee, they miscalculated my pre-sentence confinement credit at the beginning. They noticed that for the first time 20 years down the road. Why should they get to now suddenly say, wait, here's an ineffective assistance claim I got just in case I lose parole? I'm not talking about strategic anything. They just happen to notice it. And it is troubling that there would seem to be no limit. You bring a 35C claim 20 years from now if you have a long sentence. That is concerning to me. So help me understand it. Is there any, let's say we were to agree with you, 35A seems like an appropriate mechanism. It's been for all these years. Is there any limit to Leyva?
As currently written, I would say there isn't. Leyva broadly states, and I don't agree with the Attorney General's interpretation of Leyva, that the only claims for which the statute of limitations are renewed are those 35C claims that are related to the previously filed 35A claim. The Attorney General quoted the language of Leyva that he believes supports it. And the language, I believe, from this court was, as read by the Attorney General, comports with the purpose that you should be allowed to renew claims that are related to. It didn't say limited to. It could have.
Yeah, and it didn't, there's no question, but those were the facts in Leyva. We clearly had the relationship.
But I think there was a relationship, but I don't think it was limited to that, particularly given, as the Court of Appeals recognized here, the scope of the remand, the reiteration of the holding in broad terms. But be that as it may, let me get to some more reasons why I think there isn't a limit necessarily within the text of Leyva, but it still makes sense. One limit is the prohibition on successive 35Cs. A lot of these cases are going to come up where someone has already raised a 35C, and they're not going to get to file that second 35C. Leyva doesn't authorize the filing of a successive 35C petition if subsequent to your first 35C, you find an error in pre-sentence confinement credit. That's one protection. Another protection, and this is a tangible one as well, is the federal habeas limit. You have a 1-year statute of limitations for filing your 2254 habeas petition. Nothing in Leyva authorizes renewal of that statute of limitations. And so I certainly understand the court's concern, and in the abstract, I get the argument. I understand the attraction of it. But I don't think it's a tangible problem that has, I think we've seen evidence of it, and I think the successiveness bar and the fact that people would, if they waited 20 years to file their 35C, would have lost their right to file any 2254 habeas petition is a real consequence.
Sorry, let me piggyback on Justice Gabriel's question. Why isn't it fair to put a time limit on a defendant to file a motion seeking credit that he's entitled to? I mean, this is credit that a defendant is entitled to receive against his sentence. So the defendant has every incentive to want to get that credit. Why isn't it fair to have some type of time limit? I mean, we place time limits on motions to reduce sentence, right? 126 days. Again, that would be a kind of motion seeking relief that would benefit the defendant, that he or she would have every incentive to try to get. Why isn't it fair to try to place some time limitation on that?
Three responses, Your Honor. First, I don't think you're comparing apples to apples, respectively, on the time limit for seeking reconsideration. That's a discretionary decision. Entitlement to pre-sentence confinement credit is mandatory, and so I think there's a distinction there. But be that as it may, I think there's a couple other reasons. One, as this court knows from the decision of Venzer, which Justice Coates wrote, and the cases that followed, sometimes it's not clear that a sentence is illegal right away. Venzer, I believe, was decided in 2005, and we had, I don't know how many people sentenced illegally under the Sex Offender Lifetime Supervision Act for 8-10 years before that became clear. And those sentences were regularly a problem. And so it wasn't clear that they were illegal and that the claim should have been brought earlier than it was. And the final point is, if it's going to be a collateral challenge to a pre-sentence confinement credit, the denial of pre-sentence confinement credit, there are a lot of individuals who are going to finish their DOC sentence before they get the opportunity to bring that collateral challenge, because the appellate process takes a long time. And so they're never going to get to bring that claim if they don't bring it on direct appeal. And they are going to serve extra time, either because their parole eligibility date was miscalculated based on the failure to award full credit, or perhaps even serving a longer sentence, depending on revocations and things, than was statutorily authorized. And so that's why I don't think there's a real problem here that needs to be solved. Alternatively, turning to the Attorney General's argument about 35C being the correct vehicle, the first point I would make is Justice Marquez asked what provision of 35C would apply. And I had that same question because the answer brief, or the opening brief, doesn't say. It just says 35C. The Attorney General now says it's 35C, I don't know, 6, I guess, 6, the judgment of conviction, and that we should essentially do what the Court of Appeals did in this case as to the SVP determination. Well, the Attorney General disagreed with that until today, because they took the opposite position in the Court of Appeals and said the SVP designation could not be challenged under 35C. And so I think that raises a lot of questions about the propriety of a 35C motion. And as Justice Samora pointed out, restitution under 32B is listed as a separate component of the judgment of conviction, but is considered part of the sentence. It's listed separate and apart from the sentence, but I think everyone agrees it's part of the sentence. But there are tangible problems created beyond the statutory interpretation question here. And that's the most prominent one, I think, is that a defendant, as in this case, will file a motion for extra pre-sentence confinement credit once they figure out they're entitled to it. They're not going to know it's a 35C. Maybe they will after this decision if that's the way the court rules. But there are going to be a lot of defendants who file these pro se motions, don't know what to call it. The court is going to construe it as a 35C, and if it's conceded that you're entitled to the credit as it was conceded here, that might be all that happens in the court, and it's awarded. And then when the defendant's direct appeal is over, or years down the line when the defendant says, but still within the 3-year time limit for 35Cs, goes, my attorney was ineffective. And I now know that, and I have evidence of it, and tries to bring that 35C, it's going to be successive. And in fact, that's what the Attorney General argues in their brief in this case. There's a footnote where the Attorney General says that my client's SVP motion is successive and should have been denied on that ground, although that issue's not before the court because they didn't petition for cert on the SVP determination. So if pre-sentence confinement credit motions are properly brought as 35C motions, a lot of defendants are going to be shut out of court on 35C motions, which are going to be deemed successive. Now, all of those don't have merit, I grant that, but some of them do. And ineffective assistance of counsel is a real problem. You can't raise it on direct appeal, and I think a consequence of ruling that 35C is the proper vehicle here could shut a lot of defendants out of court in violation of their right to counsel.
Mr. Mueller, what about the argument that the state makes that if it's 35A, it's a sentence arrived at in an illegal manner rather than an unlawful sentence?
I don't agree with that argument because the manner claims are about procedure. And here, at least in this context, it's been undisputed all along. It's 18 days. No one has objected to that. There was no procedure at issue. The Attorney General did provide supplemental authority from last week, I believe, a Court of Appeals decision. Starts with a K. I'm not going to try and pronounce the last name of the defendant because I will screw it up. But it's an illegal manner claim having to do with the imposition of restitution. And in that case, Judge Tao cites a few cases talking about what illegal manner claims are. And often they are claims involving, as I said, procedure. The failure to allow the defendant to allocute as required by the rules of criminal procedure. The failure of the district court to consider mitigating evidence as required by the rules of criminal procedure. Or failure to consider all the different evidence the court is required to consider in imposing sex offender conditions or determining whether someone is a sexually violent predator. Those are procedural things. This is substance. This is the length of time the individual will spend in prison. And I think that's what distinguishes it from a procedure or manner claim. Substantively, we're talking about the end result of the time in custody, not the method at which the court arrived at that. The final point I make about practicalities and problems is the notion of latches. We already have latches defense. So notwithstanding a 35C claim being timely in the parade of horribles we've heard about, I think if there really is a stale claim that might nonetheless be timely under 35C because the statute of limitations was renewed based on 35A, this court's already recognized that latches provides a defense for the government in certain cases. And I think that's the proper vehicle. And this, I think, goes to Justice Gabriel's question as well about the limits on leva. So we've talked about 35C a bit and why I don't think that's the proper outcome. I do want to say, because it was mentioned briefly in the argument and it appears in, I think, the Attorney General's brief as well as a third possibility, which is Rule 36 about clerical errors. And this court recently issued a decision in People v. Wood, which addressed the nature, it was by Justice Samore, addressed the nature of what a clerical error is on the judgment of conviction. And I'll just be candid with the court. If I'm going to lose, I would much rather lose and have the court say this is a clerical error, and I think that might actually be consistent with the decision in Wood. My first position, of course, is that this is a sentence, it's part of the sentence, and 35A, sentence is not authorized by law, is the way the court should rule. I think that's consistent with Massey and Freeman and the statutory language. I think 35C is not the proper vehicle. And so if it's not 35A, I think 35C would be an appropriate vehicle. It would allow defendants to get that fixed at any time, as the rule
You mean
says.
The 36?
36, I'm sorry. 36, it would allow at any time the correction of an erroneous or a clerical error in the judgment of conviction. The court wouldn't have to discuss leva in that case because I think the court could send Mr. Baker's case back to see whether his 35C, although untimely as measured from the original judgment of conviction, was nevertheless justified by justifiable excuse and excusable neglect. I don't think there's going to be much dispute about that he's entitled to file his 35C out of time, if that's what the court rules, that it was out of time, because here he was relying on clear binding authority from the Court of Appeals in Roy that he could bring a pre-sentence confinement credit claim under 35A, and leva, although we certainly disagree about the scope of it, I think he's entitled to rely on the holding of the court, which is that it renewed the statute of limitations. So I think in Mr. Baker's particular case, he should get a new SVP determination, because even if it's an untimely 35C, it's excused based on his reliance. I'm not sure the Attorney General really disagrees with that. The Attorney General says the proper thing to do is to send it back to the court because there are some factual findings to be made, and I think the court could say, as a matter of law, this was justifiable, but I'd be fine with that remedy as well. So now I would like to talk a little bit about why it's part of the sentence. And I think this
Actually, before you do that,
I'm sorry, yes.
could I bring you back around to Rule 36 as a possible avenue for addressing these types of claims? Do you think there are different types of PSCC challenges that fall outside? I mean, I could see some that would clearly be a clerical error if there was just a miscommunication between what was uttered in court versus what winds up on a minimus. But when the nature of the challenge is around the substantial nexus and whether you're entitled to the extra 108 days, as in the prior case, is that really a clerical mistake that would fit under Rule 36?
I agree with you, Your Honor, and that's why first and foremost, I think 35A is the proper vehicle here. But because, in my view, 35C is off the table, there's got to be a way to do it. And so I would say 36 is the alternative if 35A doesn't apply. But I grant you, if it is a transposition, here's 18 days, if the court had written
16
8 days,
or 8
instead,
days,
forgot the one, that is a clerical error. And that is more in the nature of a clerical error, certainly, than the legal question of whether there's a substantial nexus, as was argued in the previous case. That's different. I certainly grant that. I'm not sure 36 doesn't fit perfectly, but I think it would fit better than 35C.
Okay.
So why is pre-sentence confinement part of the sentence? I think the most straightforward answer is that because it affects the length of the sentence. It affects the time the defendant actually served. And I think that reality overcomes any statutory interpretation argument about the meaning of the word. In particular, given what Justice Samore pointed out, which is that restitution is a separate part of the judgment of conviction under 32B, not part of the sentence under that rule, but is still considered part of the sentence for purposes of appeal and things like that. I think this court...
Can I follow up on that? I'm sorry. So what about earned time credit and good behavior credit? Are those part of the sentence as well? They affect the amount of time that a defendant serves.
They are not, in my opinion. And the reason they are not is because of three things. One, they are discretionary. Earned time credit can be awarded based on the time you earn and good behavior and things like that. DOC, that's point one, it's discretionary. Pre-sentence confinement credit is mandatory under 18.1.3405. It uses the word shall. Point two is that's earned time credit is the sole responsibility of the Department of Corrections to allocate, determine, and measure. Department of Corrections can revoke it, can take it away after it's been awarded, whereas pre-sentence confinement credit is mandatory, cannot be taken away. And third, the duty to calculate and note pre-sentence confinement on the minimus and the judgment of conviction is the district court's responsibility. It's in the sentencing statutes. It says it's the district court's responsibility. Earned time, good time is in Title 17. It's clearly part of DOC's responsibility. Now, I certainly understand DOC has a role to play in pre-sentence confinement credit, and this court has held that where there are multiple sentences and there's proper credit on the minimus, DOC is in charge of allocating, but DOC is also in charge of calculating parole, and parole is part of a sentence. This court has held. So I don't think the fact that DOC has some role to play means that pre-sentence confinement credit is not part of the sentence.
Can I ask a question on that? With regard to the sort of broad argument we've been hearing all today, do you think there's a meaningful difference between the length of a sentence and the question how much of a sentence has been served? That is, you say it's part of the sentence, and yet on its very face, it doesn't change the options for a sentence. It is a determination of how much of that certain sentence has already been served.
Right. I don't think there is a meaningful difference. I think the only difference is that it happens to be served before the sentence is formally imposed, but it's still part of the sentence because it reflects the actual time the defendant spent in custody. And so I don't think there is a distinction between the formal imposition of, say, a 4-year sentence and the 6 months, which is the hypothetical we heard earlier. It just happens to be the timing of it. When did that 6 months in custody occur? And in this case, or in that hypothetical, it would occur before. before the sentence was formally posed. And I think Massey and Freeman, which this court decided, although they don't expressly address that question, I think do decide that 35A is the correct mechanism. I don't think it was just assumed. I mean, I don't have the briefs. I don't know if it was briefed. But I think this court, I went and pulled 35C from 1984 just to see what Rule 35 looked like. Under 35C in 1984, there was a prohibition on successiveness. In certain contexts, it's not as broad as the prohibition we have now. But the upshot of that is categorizing the claim as a 35A claim in Massey and Freeman has consequences. Because if it's not a 35A claim and it is a 35C claim, then that has consequences to what the defendant can raise in a future 35C if they can bring a 35C at all. And so I don't think it's fair to say that the court just assumed that 35A was the proper vehicle. Both Massey and Freeman say it's brought under 35A. They drop a footnote quoting the text of 35A. They don't say, we assume this is the proper vehicle. So I'm not going to say that it was briefed and argued because I don't know that it was. But I think it's a little bit stronger than a mere assumption. And I think that should guide this court's interpretation as well.
Let me follow up on the Chief's question. So if you have a scenario where the court imposes a sentence of 5 years to the Department of Corrections, and after the sentence has been imposed, defense counsel says my client is entitled to 30 days of pre-sentence confinement credit. That's scenario A. Let's say scenario B, different defendant, court says 5 years, Department of Corrections, same type of sentence. No credit for time served in that case because the defendant has been on bond. Is the sentence different in those two cases, or is it a 5-year sentence in both cases?
Well, I think a couple answers. The first is that for purposes of 35A, the sentence, the 30 days of pre-sentence confinement credit is part of the sentence, is my first position. Although in the abstract, non-technical sense, I think the sentence is 5 years. But I think Your Honor's question highlights an important point here, which is that the whole purpose of pre-sentence confinement credit, these cases back from the 70s, before there was a mandatory a rule requiring pre-sentence confinement credit, is that it was affecting people without means disproportionately, because people who had money were bonding out and not serving time in custody before the sentence. And so what ended up happening, and surely this still happens, is that people without means are spending time in custody that people with means aren't. And that's why the statute was enacted, to ensure the full entitlement to pre-sentence confinement credit. And I think it's part of the sentence whether it's been served. I just think it's part of the sentence. It's the actual time served. I think that's the plain meaning of the word sentence. And I think the statutory arguments to the contrary are really unavailing, just given what a sentence means. But even if we're going to talk about statutory arguments, words mean different things in different contexts. The word conviction has, I don't know how many meanings under Colorado law, depending on what you're talking about. A deferred judgment or sealing something, it means all types of things. So the fact that sentence might not mean one thing in one context doesn't mean sentence in a different context under 35A. And so I just think, practically speaking, the amount of time the person spends in custody is part of the sentence. And if the credit's not given, they're going to spend longer than authorized by law. And that leads to the next point, which I'll just briefly make, which is that the alternative argument from the Attorney General is that it's a manner claim and that it's not a not authorized by law claim, and that not authorized by law is limited to the sentencing scheme, I think, is the language. Well, I think 18.1.3405 is part of the sentencing scheme. If unlawful or not authorized by law was limited to the ranges of sentences available to the court, surely that could have been written down somewhere. It could have said not authorized pursuant to 18.1.3401. That would have made it clear that what we're talking about is the presumptive or aggravated range, depending on the case. But it doesn't say that. It says the way it's been interpreted is statutory scheme. and pre-sentence confinement credit is part of the sentencing statutory scheme. The last point I'd like to make, assuming this court has to get to Leyva, that case was a statutory interpretation case. It was about the meaning of the word conviction in 16.5.402.1. That case has been on the books for 10 years, 9 years. Now, the General Assembly could have overruled this court's decision if it thought it was incorrect. The General Assembly has not done that. In fact, the General Assembly has amended 18.5.402, amended it in 2008, and it didn't change the definition of the meaning conviction. So if that's a problem, I think it's a problem that the General Assembly needs to decide. And similarly, the plain language of 35A justifies what happened here. I don't think the court should torture the meaning of the rule or plug things into holes where they don't fit to reach an outcome based off of a problem that doesn't exist. So if there is a concern, and I certainly understand the concern about gamesmanship and sitting on rights, the proper remedy is to amend the rule. And the court can do that. And the court can solicit comments, and that's the way it should be done, because the law is clear. And I don't think there's any compelling reason to overturn laws or decisions that have been on the books for a decade or more when there's no evidence that they're causing any problems or leading to bad consequences. And when the alternative, without consideration through committees, if it's a statute, or through notice and comment, if it's a rule, would lead to problems and people being locked out of court, and I don't think that's fair. If the court doesn't have any other questions, I'm happy to waive my 30 seconds of time. Thank you.
Just a couple points in response to Mr. Mueller's argument. He asserts that the 16.5.402 shouldn't be given effect because this court has other procedural bars in successiveness and latches. And it's my position that the legislature passed this statute, and it's this court's job to make sure that intent is carried out. And a defendant may not have sat on his rights to fall under latches, and he may not be successive. So if that's the case, then 16.5.402 should control. I think in a lot of pre-sentence confinement credit cases, people talk about fairness, and they say this is unfair, and the statute is mandatory. Well, all laws are mandatory. So I think a good example is Blakely. Blakely is mandatory. We all have to follow Blakely. And a defendant's sentence, two defendants sentenced on the same day have the exact same Blakely error occur. And a defendant like this one finds 16 days of pre-sentence confinement credit. He is all of a sudden timely 4 years later, and the other defendant is out of luck. And I would submit that's not fair and what the legislature intended. The legislature intended both of those individuals to be out of time because they had 3 years to bring their claim. And if they didn't, their claim is stale and it's denied.
What's your response to the concerns expressed by Mr. Mueller if we find that PSCC is not part of the sentence and Rule 35C would be the vehicle to seek correction of that?
My response is that already occurs in a lot of situations, and you could take it as a hypothetical or my experience, defendants can make what I would say are small 35C claims, like terms of probation or things like that, and then their probation gets revoked, and they get sentenced, and then they make an ineffective assistance of counsel claim, and they're successive. And that's just the nature of the rules. And if this court made clear that it's part of 35C, then trial courts will follow that, and defendants will be aware that that needs to be one proceeding, and they need to bring all their claims. Part of Mr. Mueller's argument is that this isn't happening, and I would submit it is. But if it's not, if this court says you can do this, I assure you there will be claims that where people have found, will find pre-sentence confinement credit and then file an untimely 35C. And lastly, he said, this court can make a rule. Well, I understand that argument too. This court can make a rule to change the meaning of conviction in 16.5402. The issue in this case is, what does conviction mean? And I agree, it means a lot of different things in a lot of different cases. But the issue is, did the legislature intend an exactly correct finding of pre-sentence confinement credit to be included within the term of conviction? And as I said in my brief, I would submit that the answer to that question is, of course not. They wouldn't have intended a, not insignificant, but a part of the procedure where we are literally talking about days to affect the finality, to somehow transform a conviction to not being final years later. Justice Hart, in response to your question on restitution and an illegal manner claim, I think a good way to compare it to the restitution arena would be, you have restitution, you have the hearing, everyone pretty much agrees on the amount, and the judge puts the amounts on the minimus, and then a year later, 2 years later, the defendant says, well, you forgot to present some evidence at the restitution hearing, or there was this undisputed evidence that people forgot about. That's what this is. There's undisputed evidence that he was in jail in another state before he was extradited to Colorado. And under, I agree, I can't pronounce the name, Canooption or something, that's a manner claim. That is the process. The process is what evidence was presented. Here we think of it, there's not usually any evidence. The evidence is, defense counsel, how much time is he entitled to? And he says 100 days. And you say, prosecutor, what do you think? Yeah, that sounds fine. Okay, 100 days. That is the process that occurred. I have 4 minutes left, but we should all see how hard it's snowing. Let's see what
It's
happens.
snowing pretty hard.
I'll sit down then if no other questions. Thank you.
Thank you. Thank both counsel for your arguments, especially since you were probably thinking about how you were going to get home. And the court will be in recess.